I'm delighted to have AngusMacinnis here, a lawyer with Stevens Varan. And Angus is very active on social media, gives all sorts of public presentations, writes about this in the professional literature. And it's just great to have you here today. Angus, welcome.
Thanks, Mark. It's good to be here.
We're talking about intellectual property today, although your work does span a range of fields, including commercial law and consumer law, those sorts of areas. Do you mind just explaining very briefly the types of law that you cover?
Well, I'm a commercial lawyer who has quite a broad practice. I do quite a lot of intellectual property work. I do quite a lot of employment law work, and in terms of the social media stuff, I do IP and employment cover a lot of those sorts of things. But basically, if companies need assistance in greasing the wheels of commerce to make things move, then that's the sort of work that I do across quite a broad area.
In a nutshell, what do we mean by intellectual property, Angus?
Well, it's one of those things where there are probably about as many definitions of intellectual property as there are lawyers giving them. But if you look at the two parts of it, intellectual in the sense that it generally involves rights that come from creativity or innovation or those sorts of aspects, and property in the sense that you can do stuff with it that you can do with property. So you can own it, you can transfer it, you can give other people the right to use it, you can go down to the bank and borrow money against it. And so those are the idea that you get property rights as a result of your creativity or your intellectual endeavour. And I guess the two other important things about intellectual property rights are that they're governed by legislation, so Parliament can give, Parliament take away, and also in most cases they're economic rights. So you're talking about how am I going to make money from what I've done, or how am I going to prevent other people from using what I've done unless they pay me some money for it.
Well, that's a great summary, thank you. And we've obviously got copyright sitting there as part of intellectual property. So what distinguishes copyright?
Well, copyright are the rights that go with creators of works, and that's not particularly helpful. But then you say, okay, well, what are the works? Well, there are things like literary works, so books, but also things like course notes, training materials, musical works, obviously a bit more straightforward, dramatic works, and then artistic works covering things like sculptures, what we understand to be art, and photographs and things like that. So in copyright, it's generally a question of saying, okay, I have created this work, or I am the author, and because of that, I've got some exclusive rights that to reproduce the work and to prevent others from reproducing the work unless I've agreed to let them do so.
Journalists then, as creative people and producing works of this kind, along with their affiliated industries, public relations, and I suppose bloggers, these sorts of people, they can get affected by copyright in a range of ways.
Well, that's exactly right, Mark. And as you say, journalists are in that position where they are creators of copyright. So if you're a freelance journalist, for example, you might be interested if you sell a piece to a particular publication as to what rights they then have to syndicate or to on-sell the piece. Because obviously if somebody's got the right to do that to your piece, then you might want more money than if you're only allowing them to use it in a particular publication. And then in relation to using other people's copyright works, obviously things like photographs, which often arise. Somebody might be provided a photograph for one particular limited purpose, and the photograph then might be used for a much broader purpose. And in fact, in 2013, there was an interesting case involving a book about Chappelle Corby and a number of photographs which were used in that book where the publisher didn't have the rights to use those, and where some damages were paid to the members of the Corby family who in fact owned the copyright in those photos.
I think that involved my publisher, Allen and Unwin, and so we'd better move on to another topic. It's interesting that journalists, particularly in this modern era of social media, are quite tempted to jump onto somebody's Facebook page or to take a twit pic. Is this within the bounds of copyright?
Well, yes, and if I take a photo, then that's a copyright work, and if I put it on my Facebook page, then I'm making certain consents to let people use it, because obviously if I put a photo on my Facebook page, then in order for you to see it, you've got to make a copy of it by downloading it on your computer. There are some what are sometimes called implied licenses from putting stuff on the internet, but it's one thing to say, well, I'm happy for you to view it in a private sense. It's another thing again to say that I want to see it, on the 6 o'clock news as being a photograph that's being reproduced all around the world.
And that has happened quite often. So, I mean, it's a bit of a dilemma, isn't it, that you might have, say, for example, a major disaster victim or a celebrity's relative or something that's gotten into trouble, and the media are quite tempted to take it off their Facebook page. What are the consequences of doing so?
Well, the consequences on the face of it are that if the news agent or the news organisation is not the owner of the copyright, then it's an infringement of copyright in the photo. Often it can be very difficult to work out who the copyright in the photo is. If somebody has taken a picture of me, which they've supplied to me, and then I've then put it up on my Facebook site, I'm not the owner of the copyright in the photo just because I'm in it or because I've put it up on the Facebook site. The owner of the copyright is the author, which is generally the person who's taken the photo. So it can be very difficult to track back to who the owner is, and obviously in the context of news, where you don't have days and days to spend establishing the provenance of a photo, it can be quite tempting to say, well, it's unlikely we're going to be sued. Even if we are going to be sued, the damages aren't going to be significant. Let's just put it up and see where it goes.
And that's often what happens, isn't it? Because the reality is that while we do have this area of the law that can be pursued, the reality is that probably even if a media outlet is pursued for breach of copyright, it's unlikely to face a huge amount of damages as a payout. They would probably settle out of court for something quite reasonable.
Yeah, that's right. Well, and there are exceptions under the Act, and one of the things about discussions about reform of the Copyright Act is how well those exceptions for media organisations operate, because there is always a tension in these issues between saying, okay, well, we want to protect the rights of people who have created works, in this case photographs, but also the community as a whole sometimes has an interest in having information communicated to it. So it's a question of balancing the right between saying, well, we don't want people to create works and then have those works taken without being paid, but we also want to make sure that there's no sort of monopoly on information that the public otherwise have an interest in having communicated to them.
And I think there is that tension because, there'd be a big difference between, say, a freelance photographer who took an award-winning photograph and that was then stolen and syndicated by news organisations. A difference between that and some ordinary citizen who just happened to be at the scene of an accident and took a photograph and it wasn't their livelihood. You'd imagine different damages in those two different situations.
Well, that's exactly right. And that comes back to what I said earlier about copyright being mainly an economic right. And obviously there's a difference between, and if you look at infringement cases, the damages are calculated differently for somebody like a freelance photographer who says, look, I would have been happy to license the work that's been stolen, but this is what I would have charged for the use of the work, as opposed to someone who said, well, look, I wouldn't have licensed the work because it was just my private photo and there's no way I would have entered into a commercial arrangement to let you, put the photo of my dead son or dead daughter, on the 6 o'clock news.
Mm. Well, clearly the conservative approach is always to seek permission, and that's when you start to get into difficulty. You mentioned the situation earlier where someone might have posted a photograph of themselves to their Facebook page, but unless it's a selfie, it's obviously been taken by someone else who holds the copyright, and it must be hard to work out who that is.
Well, I think that's right, yes, because as I say, you don't obviously have a way of finding that out. Copyright in Australia doesn't require registration, so there's no requirement. Once you take a photo and it's there, then the person who owns it has copyright in it without the need to fill in a form and send it off to IP Australia. So you're right, it can be difficult, but I think this is really just an update on, in days gone past, people going around to see, grieving relatives and seeing some photos displayed, physical photos on the mantelpiece and saying, oh, look, can I borrow this photo for a second? So it's easier to do now because it's on the internet and you don't have to go and, visit the grieving relatives in person. But it's sort of new, or this sort of old legal issue with a new technological frame around it.
And actually, that's an interesting one because quite often the photo on the mantelpiece is something like a wedding photograph, and people do post their wedding photographs to social media. And that's actually a situation where there is a commercial photographer who has typically taken that wedding photograph and might well want to, defend or pursue their copyright in that photograph if it's being used by a media organisation.
Well, exactly right. And I know, for example, that a lot of wedding photographers do have provisions in their contractual arrangements that deal with what use they will and won't permit on social media, or whether they will or won't retain the ownership of the originals, or what digital images they will provide at all as part of the package. And again, that's just a question of negotiation, and the photographers saying, well, if you want the digital images, then that will cost you more than if I get to retain control over those images.
Now, a related area, I've seen some debate about whether a tweet, the words of a tweet, can actually be protected by copyright. I've seen some arguing that it's far too short and that, it's only 140 characters and nobody could really say anything that original in 140 characters. But then, on the other hand, some people you follow on Twitter do say some remarkably original witticisms and statements within that space of characters. So what's your view on this?
Look, this is a really interesting issue, and I mean it goes back to the fact that it's normally said in relation to headlines in newspapers that a headline doesn't have sufficient originality to the copyright work, but you can still win a Walkley for writing excellent headlines. So yes. I think there's some irony there. It's difficult in the sense that copyright is not said to subsist in the mundane. So there needs to be some originality or some intellectual sweat of the brow, or sometimes the expression that's used. It does seem to me to be a bit odd that if a single line of poetry or a haiku, for example, are capable of being copyright works, that a tweet would not. And I suspect it might be one of those things where you have to give the terrible lawyer's answer, which is to say that it depends. And that if you could show that there was a particularly skillful collection of your 140 characters, then you may be able to get copyright protection. But I think on the principle that headlines generally don't get protection, that you probably say probably not. But as I say, a particularly skilled tweeter may be able to show that they've laboured for days on a tweet, and if they could do that, then they could probably attract copyright protection.
Well, I certainly won't be stealing one of yours to test that, Angus. That might be dangerous. Yeah. Now, I understand from a prominent recent High Court case, the INET case, that internet service providers might not be responsible for people who use their service breaching copyright, even in a very blatant way.
Yeah, well, that's about authorization. So if a person can directly infringe copyright by, in this case, downloading an infringing copy of a movie or a song. But if you provide someone with the means to infringe copyright, then you can be liable as an authorizer of that. And this is not a new concept. The sort of early authorization cases were people who hosted dance bands, and the bands were playing music they didn't have the right to play. Then there was the case of the University of New South Wales and Morehouse, which was about photocopiers and whether or not universities were authorising copyright infringement by providing photocopiers as a means to do that. And more recently, we've seen authorisation in a lot of internet cases. And authorisation is a good tool to use to try and stop copyright infringement, because if you've got a very large number of people who are downloading a particular movie, a particular song, it's very hard to go after all of them individually. But if you can go after the large company which provides the means for them to do that, then you can shut down a lot of the individual infringement, and you're suing somebody who you can find and has got the money to pay any damages. So INET was about authorisation, and the High Court found that in the circumstances of that case, INET, although it was not doing as much as it could have to prevent piracy, was not authorising it in the sense that it wasn't unreasonable to be doing what it was doing and no more.
Are there many reforms that you would suggest to copyright law?
Look, I think it's one of those classic areas where technology is moving more quickly than the law does. And I think in the law, and obviously any law which is able to be broken by lots of people all the time, is probably a law which needs to be changed. So one of the main proposals at the moment is to sort of cut out a lot of the complexity of copyright law and to provide an exception for fair use, and to look at a number of these sort of non-commercial infringing uses and to provide a basis on which, if the use isn't going to harm the owner of the copyright, that ought to be a permissible use without the need to go back and get permissions and licenses and sort of track back through that process we discussed. But I think there are obviously very strongly held views on the part of people who want to use information and use as much as they can for free, and people who create information, and people who would have rent to pay and like to be able to eat, and would quite like to be able to get out of their creativity some economic benefit from what they do.
Well, it'll be interesting to see how that reform process unfolds. Look, Angus, thanks so much for sharing your expertise today and explaining it so well for the lay listener.
Oh, thank you. It's very much a pleasure. Thank you for the opportunity.